Despite a successful slave revolt against the French at the turn of the 19th century, the Haitian people had suffered under a series of repressive government regimes. On February 7, 1991, Reverend Jean-Bertrand Aristide was inaugurated as Haiti's first democratically elected president. Unfortunately, after only 7 short months, Aristide's government was overthrown in a military coup, forcing Aristide to flee to Venezuela. In the months following Aristide's removal, thousands of Haitians, including Aristide supporters who feared violent retribution, followed Aristide's example and took to the sea. Unknown to these Haitian refugees, the United States Department of Justice had attempted to streamline the procedure for repatriating Haitians since 1979, through the implementation of what was known as the Haitian Program. With the approval of former Haitian dictator Jean-Claude Duvalier, President Ronald Reagan had even established a policy of interdiction in 1981, which permitted the U.S. Coast Guard to patrol the waters off the coast of Haiti and stop, board, and inspect vessels. Known as the Alien Migrant Interdiction Operation, the policy ordered refugees to return to Haiti if they could not prove they had a well-founded fear of persecution. According to the U.S. Immigration Service, between 1981 and 1991, over 400 boats were intercepted. Over 25,000 people were questioned, and only 28 were granted asylum in the United States. In the closing months of 1991, men, women, and children poured out of Port-au-Prince and other port cities around the country, desperate to escape the wrath of Haiti's Tonton Macoute army. All told, the military crew had created between 200,000 and 300,000 refugees. Over 30,000 of them headed for the United States. During the initial phase of this mass exodus, President George H.W. Bush altered the existing interdiction policy and began holding Haitian refugees aboard U.S. Coast Guard boats known as cutters. When that solution proved ineffective, given the number of people and the blazing conditions aboard the cutters, the U.S. government turned to its naval base at Guantanamo Bay. In early 1992, over 10,000 Haitians had been paroled into the U.S., and thousands more were being held in 6 camps established at Guantanamo. However, in May of that year, the number of refugees was so staggering that President Bush issued what came to be known as the Kennebunkport Order. This order authorized the interdiction and forced repatriation of Haitian migrants picked up by the U.S. Coast Guard on the high seas. Refugees fortunate enough to make it to Guantanamo before the declaration of the Kennebunkport Order were not guaranteed asylum. Most were denied asylum and returned to Haiti. Others waited and waited. The temperature in Guantanamo Bay ranges between 70 and 90 degrees, often reaching up to 100% humidity. The camps may have been an improvement from conditions aboard the cutters, but lack of running water, poor sanitation, and bland food kept spirits low. Making matters more complicated, the Marines stationed on Guantanamo were not trained or prepared for so grand a humanitarian mission. By the spring of 1993, the makeshift facility had expanded to accommodate over 10,000 refugees. Back in the United States, a group of lawyers had been taking action on behalf of the refugees. On December 20, 1991, lawyer Ira Kurzban and a group of his associates had filed what was initially a successful injunction stopping the Bush administration's forced repatriation. Unfortunately, the Supreme Court denied the petition in February of 1992 with their ruling in the Haitian Refugee Center v. Baker case. In addition, the injunction was vacated by the 11th Circuit Court in Atlanta. However, the failing of the court case did not deter another group from taking up the torch. Yale Law professor Harold Koh and students from Yale's Lowenstein International Human Rights Law Clinic took on the case for a second time. They enlisted constitutional rights attorney Michael Ratner, Joseph Trignali from the well-funded Simpson, Thacher, and Bartlett law firm, and others to assist in what turned out to be a multi-part legal battle to free the Haitians with the Haitian Centers Council versus McNary court cases. Initially, Cohen Company won a temporary restraining order from Judge Sterling Johnson preventing the U.S. government from forcibly repatriating the Haitians. They argued that the refugees were entitled to access to legal counsel during their asylum hearings, but had been denied that right. President Bush issued his Kennebunkport Order while the appeal of Johnson's ruling was pending. The Yale team filed another temporary restraining order directly challenging the Kennebunkport Order as a violation of Article 33 of the Refugee Convention as well as the Refugee Act of 1980, both of which worked to prevent the forcible return of refugees to the dangerous environments from which they had escaped. While the first ruling was upheld and granted the lawyers access to their clients on Guantanamo, Judge Johnson denied their second petition. Interdiction and forced repatriation stood. By this time, the world was becoming aware of what was happening to the Haitians on Guantanamo, specifically the ones who tested positive for HIV. These refugees were being quarantined from the rest of the population in a separate camp. Even if HIV-positive refugees were determined to be political refugees, they were denied entry into the U.S. based on a 1987 ruling in the Immigration and Nationality Act. However, AIDS awareness organizations like ACT UP stepped up on behalf of the HIV-positive captives in Camp Bulkley. While waiting to see if the newly elected President Bill Clinton would release the refugees as he had promised during his campaign, a group of disgruntled Haitians decided that they had had enough and began a hunger strike. Inspired by their Haitian clients, students from Yale also pledged to take part in the hunger strike. Soon, colleges across the country became involved, passing the hunger strike from one school to another after a week's time. In the camps on Guantanamo, the hunger strike lasted for months. In the spring of 1993, Coe and his cohort set out once again to challenge the federal government. This time on the grounds that the imprisonment of HIV-positive individuals denied them rights of due process, including access to adequate medical care, decent living conditions, and rights to counsel. Judge Sterling Johnson once again ruled for the plaintiffs, and on June 21, 1993, roughly 250 refugees at Guantanamo were released in the settlement of the Haitian Centers Council versus Sale court case.
The thing that really, I think, jerks at you is that the Haitians, they were refugees. They were the most classic refugees of any refugees group I know. I mean, they were sort of the hardest threshold to beat to prove you have a well-founded fear of persecution is that there's a pattern and practice of persecution of people like you. And all you had to do was be poor in Haiti. If you were poor in Haiti, you were supporting Aristide. If you weren't, you were assumed to. I mean, it was the clearest refugee flow that we've ever had. There couldn't have been. It wasn't a person coming, and that's what scared them, really. It wasn't a person coming out of Haiti who wasn't a refugee. And they said they were economic migrants. But our refugee law has improved some, and a lot of us have worked on that. And there's now recognition of mixed motives. If you can believe it, it's taken this long that actually somebody can have economic motives and political motives for things. People don't have just one motive floating on their head for their lives. It's kind of ridiculous on some level, but I mean, it's really important that that the younger generation keep it up, because we don't want to end up where Australia's at now. I don't know if you know what they're doing, but they're offshoring their refugees and they're they're paying off like Malaysia and Papua New Guinea to take their any refugee who arrives by boat. There was a New York Times magazine article about it 2 weeks ago. That's unreal to me. It's unreal. I'm so embarrassed by working in Australia. Let's not get there.
Let's not get
do that.
there.
Yeah.
Let's not get there.